Now back to the show. This is The Law Show on CL 650.
Yes, you can't always get what you want, but my gosh, it's sometimes worth a fight. Or not. The Rolling Stones, as we come back to The Law Show with John Lakes and John White from Lakes White LLP in North Vancouver. They are estate lawyers and litigators, and we're talking about undue influence. In John Lakes, there's the matter of the Bull estate versus Bull. It's a recent BC Supreme Court decision that you brought today to talk about and use as a point to illustrate this whole matter of competence and undue influence.
And, well, not only that, but the issue of the actual will document.
Okay.
Because the key is you want the will document to survive your death. And, of course, you're not there to give your evidence, but you need other people who can defend the will.
Right.
So if you use a professional person such as a lawyer or a notary to do the will, first of all, costs aren't going to be that high compared to court costs.
Right.
But they're also going to make sure that they are an independent third party to make sure that when you sign the will, you're competent, you're acting freely and voluntarily without fear of intimidation, which means that will should survive the challenge. And a good example of that is the Bull case, which John will talk about, which is a very recent decision of the Supreme Court of British Columbia.
Right. And so what was this? What's the background of the case here, John?
Well, it's really a case more about testamentary capacity than undue influence. But it's a situation that you see from time to time where there are two children of the will maker, and one of those children receives considerably more
than the other.
Okay. And which is entirely legitimate. Will makers can do that if they want. It does tend to set in motion disputes just like this one.
But it's perfectly legal, though.
Oh yeah, it's
okay.
completely legal.
Okay.
I mean, we call it a will because
this is what I want to do with my estate.
That's right.
Right.
It sets out what your will is.
Right.
But here's a case where mom left more to her daughter than her son, essentially because she says her son was a bad boy when he was a teenager.
Okay.
And
gee, there's a first, huh?
Yeah.
Okay.
There's nothing new under the sun, I suppose. And by the time it gets to court, the son is saying, well, mom was delusional because I was a loving son and I had a great relationship with her, and she wouldn't have left me with as little as she left me with if she'd been in her right mind.
Oh.
So she therefore must not have been in her right mind. She didn't have testamentary capacity to execute the will that she did. Problem for son is that mom did the smart thing, which was she went to a lawyer who knew, in fact, a series of lawyers, because she wrote a series of wills. These people knew what they were doing. They were very good lawyers. They did exactly what they're supposed to do.
Right. And followed her instructions as well. So she knew what she was doing.
Right. And they satisfied themselves that she had testamentary capacity.
Sure.
They wrote good wills, which and ultimately the latest will in time held up because the court recognized that you don't have to be perfect to have testamentary capacity.
As you said earlier.
As I said earlier.
Yeah.
I mean, you need to understand, in broad terms what you're doing, that you're giving away your property. You have to understand in broad terms what that property is and who the natural people might be that you should at least think about when you give away your property. Whether you wind up giving it to them or not, you got to at least think about them. Well, this lady did all of that. She did all of that in front of a lawyer. And ultimately the court found that she wasn't delusional.
So they ruled in favor of the daughter, and the son was stuck with whatever he was willed in the first place.
Well, unfortunately for the son, he was stuck with a great deal more than that.
Oh, really?
Because he was ultimately the subject of a substantial costs award. Normally when we go to court, the loser in a court case can usually expect to have to pay a portion of the court costs.
Yeah, we're familiar with that. Yeah. You
lose,
winner. You're going to get stuck with some costs.
Right, but there are situations in which the court finds that the losing party has engaged in what the courts call reprehensible conduct, conduct that is so far
you didn't
below
need to
the
do
standard.
this. Yeah,
well,
right.
it's not just you didn't, you shouldn't have brought this case in the first place. That's why the courts award costs, but bringing the case in the way that you did was reprehensible. It falls so far below the standard of what's acceptable that you really, really shouldn't have done it. It's a punitive cost order, and unfortunately, this unfortunate gentleman was the subject of an order like that because the court was that unimpressed by what he was doing. It found that he was motivated by bitterness and jealousy, and he was simply trying to grab more of the pie for himself. And the court
didn't buy it.
Didn't buy it.
And John Lakes, back to your point originally, Mom, in this case of the decision that your partner here has just informed us of, Mom did the right thing. She went to lawyers, got it done by pros, and it stood up in court.
And now, most importantly, was the evidence, too, was when the lawyers were getting instructions from the mother, nobody was in the room besides including the daughter. So if you're taking your parents to a lawyer or a notary to do a will, expect to be waiting outside.
Right.
Because the lawyer or notary has nothing to be offensive to you. We're just trying to do the job properly.
Interesting stuff. And a good point to leave it on, because I'm afraid we're fresh out of time, and we've just barely begun to discuss the whole matter of undue influence. But thank you both for allowing us to at least get a handle on this, especially as it's affected by very recent changes to wills and estates law in British Columbia. John Lakes, John White, good to see you both again.
Thank you.
We'll catch up to you again in a few weeks.
All right. Thank you very much.
LakesWhyte.com. LakesWhyte.com. Lakes White in North Vancouver. That's it for The Law Show this morning. We'll see you next time here on CIL 650.